Okay, we're going to review Salvage, which I talked about a few minutes ago in the live class here on Monday, September 8th, Section 2. This is going to be a composite of material for Module 3, which is Salvage. One of the important things to keep in mind is that salvage is one of those areas of admiralty law that is primarily judge-made law. There's no comprehensive salvage statute in the United States or in England for that matter. Salvage, for the most part, almost completely really, is just a creature of judge-made law, sometimes called common law. And it goes back, the principles of salvage go way back, and we got them, meaning the US courts, got them from English tradition and developed and built upon that. There are a couple of statutes that address salvage. We will address those later, if at all. They're in the reading. There's one that has to do with priority of life salvage. Congress enacted a statute about that. But for the most part, it's all judge-made law. The United States has a kind of what's known as a seminal case, meaning the case like a seed is the Latin. And that's called the Blackwall from the 1800s. The Blackwall was the name of the vessel. And it's a Supreme Court case that basically lays out a number of factors, they're in the reading, that a court should use when deciding how much to give as a salvage award. So you don't need to memorize them. And I think what you want to keep in mind is that they are not like a fixed system of points for each one or anything like that. When you go to court seeking a salvage award, which is generally done in federal court in the United States, really, there's no jury. As I mentioned before, most admiralty cases are bench trials. The judge, a single human being, is going to apply the Blackwall factors in whatever order and priority he or she sees fit to do. So basically, it's a guideline. The Blackwall factors are a guideline. And they might help you in writing your brief, if you're the attorney, as to why you should get X amount for the salvage efforts, or why your client should get X amounts for the salvage efforts. But they're not engraved in stone, and they are not numerically, other than being put in numerical order, they're not weighted numerically. Okay, so I have some stuff here that I wanted to go over. The top is really just a minor point. Salvage is the noun. There is actually a verb, salve, or salve, which is the verb. But that was just an aside that I wrote earlier when we were talking about this. But salvage is the noun. Now, how does it work? Well, there are two kinds of salvage situations. One is where the salvor does not have any contractual relationship with the owner of the maritime property that is in peril. So the example I can give for that is I have a motor vessel and I'm cruising around in Manhasset Bay, and it's a little windy, and a sailboat that was on a mooring, I guess the line kind of frayed or whatever, and I see it drifting down away from the mooring and it's blowing toward the rocky shore, and there's no time to call anybody, nobody's on there. So I just get ahead of the vessel with my motorboat, and my crew jumps on board the vessel. We put a line on the vessel, this being the sailboat that I'm trying to salve or save, and we tow it to safety. And if it hadn't happened, it might have been a wreck. So the owner actually owes me money. I'm entitled to a salvage award. How much? Well, that's for a judge to decide unless we negotiate a deal before we go to court. But that's a situation in which I'm entitled to a salvage award. You don't have to have the owner's permission. You don't have to have a contract. That's what is called pure salvage. And over the centuries, it has become clear in the maritime world that that's the kind of behavior we want to encourage. We want to have people going to bat to try to save maritime property rather than let it hit the rocks. And it's even more important today when hitting the rocks could mean a nasty, incident involving some pollution or other damage. So not that it never did before, but I mean, way in the back days, there wasn't as much fuel out there before we had fossil fuels, right? So a sailboat hitting the rocks isn't as bad as, some kind of a vessel that has fuel tanks that might rupture. Anyway, pure salvage is the situation that is the norm where there is no contract. If there's a contract, it's called, surprise, contract salvage. And the contract that is normally used, you'll see in the reading, is known as Lloyd's Open Form. Lloyd's Open Form is a standard contract. There are a number of versions. It's basically from England. It's drafted by people in England and updated so that there are a number of versions. And it's widely used. A distinction I want to make between pure salvage and contract salvage is this. With pure salvage, this principle applies. No cure, no pay. I do hope it's all on the screen. If not, we'll let it. No cure, no pay means that in order to get a salvage award, you have to be at least partially successful in your efforts. So if you, to use the scenario I just described, there I am in Manhasset Bay, the sailboat is going downwind, I rev up my engines, get ahead of the boat, my crew member tries to jump on board, falls in the water, sailboat keeps going downwind, I got to pull the crew member out of the water, I go racing down ahead of the vessel again, the same thing happens, the crew member is back on board, we try one more time but we don't make it, and the vessel, now the sailing vessel has picked up enough speed and has hit the rocks and is aground on the rocks and the hull is breached and it's a mess. So I was totally unsuccessful, I didn't save anything, but I really tried, and the crew member, sprained his ankle and got wet and all kinds of mess, and I burned a lot of fuel, and maybe there were other costs and injuries that resulted to me and my crew as a result of the efforts, and we sure do deserve a little bit of a reward for that, but we're not going to get an award for that. An award, meaning a salvage award. We're not going to get that. Under the law of pure salvage, it's no cure, no pay. You don't succeed, you don't get anything. You attempt to be a salver under pure salvage at your own risk. There is a minor nuance about that in the statute that has to do with saving lives, which is in the reading, but I'm not going to go down that path now. Now, the question is, what about contract salvage? Is the no cure, no pay principle still applicable? Well, I guess it could be if you want to, but a contract allows you to contract for whatever you want legally. So under the contract, you can easily have a provision that says that you'll be paid an award whether or not you're successful. And it may be a smaller award, it may be a fixed amount, it may be however you want to work it. But you can certainly have an award available under a contract salvage even if the salver is not even a little bit successful. If they render efforts, spend money, take risks, do the job even without succeeding, or try to do the job, they can still get an award. So a very important distinction between pure salvage and contract salvage is no cure, no pay rule. It's absolutely enforceable in the pure salvage context, but it may not be applicable in contract salvage because you can contract your way out of it. There was another very important principle that applies to salvage that has to do with pre-existing duties of the salver, or of the would-be salver. So, let's imagine you're the crew. You're on a ship. And there's a breach of the hull, and it's not that big. You're not sinking fast, but water's coming in, and a great deal of effort needs to be expended day and night to keep that vessel from going down. In this scenario, we can have water coming in and bilge pumps have to be operated, but maybe the power goes out and you have to manually pump bilges, and the crew has to pump like crazy to make it to the next port, which is 3 days away, and everybody's working like crazy, saving that vessel. And it's an extraordinary effort, and if it's not for those extraordinary efforts of the crew on board, that vessel would have sunk. Is the crew entitled to a salvage award? No. They had a pre-existing duty to the vessel. They don't get a salvage award. Maybe they'll get overtime, depending on their union contract. Maybe the owner of the vessel will reward them, but they will not get a salvage award under the law. They have a pre-existing duty. Another case of pre-existing duty arises where you have government entities or that sort of thing that rescue a vessel and personnel. The U.S. Coast Guard goes out there to this vessel that's foundering 20 miles offshore and rescues the people on board and tows the vessel back. Is Uncle Sam entitled to an award, a salvage award? Absolutely not. They have a duty to do that. However, these days, in recent years anyway, you're seeing the Coast Guard and other entities like that bill people for the the government resources expended to do that. But that's not the same as a salvage award. They're not entitled to a salvage award. I gave a hypothetical earlier that I want to talk about now that sort of fleshes this out. It's actually not a hypothetical, it's a real phone call I received from a salver who had successfully saved a sailboat from going downwind onto the rocks. So I got the phone call and he told me that he had had a contract to tow this vessel from a mooring where it was moored safely and take it to another marina. And he went over there, and just as he was arriving, he found that the vessel had just broken loose from that mooring and there was wind, and there was nobody on board, but he had a contract to tow it. So he went and really chased it and went to extraordinary effort to keep it from hitting the rocks, the kind of thing I described earlier, runs down ahead of it, gets a crew member to jump on board, gets a line, but it was, action hero kind of stuff. And certainly he expended a lot more effort, time, and risk than would have been the case had he done the job he was contracted to do, which is just tow it from one safe mooring to another safe mooring. But instead, he had to go through all this. So he was interested in having me go to federal court with a salvage claim, and presumably on contingency, meaning that I would get a percentage of the recovery. And I said no. The reason I said no is because he had a pre-existing duty to that vessel. True, it wasn't the same pre-existing duty as the actual steps he took. The duty was to tow the vessel under calm circumstances from one place to another, and he actually went above and beyond that, above and beyond what he had to do under the contract. But if you think this through, let's suppose I went into court seeking a salvage award. His defense counsel, the sailboat owner's defense counsel, would immediately, if they were competent, raise the issue of this pre-existing duty. And then I would have to find, if there is such a case in which, somebody with a duty like this went to extraordinary efforts and was still given a salvage award. This is a phone call. I wasn't about to do 2 hours of legal research to find it, and I don't even know if the case is out there, but certainly what that would have meant is that I would have to expend a lot of time and resources just to stay in the game if I brought the case, because any competent lawyer would move to dismiss on the basis that this would-be salver had a pre-existing duty and was therefore not entitled to an award under the principles of pure salvage. So I quickly said no to that. We also discussed, this by the way is a rehash of the earlier part of this class, so I'm doing it as a review for those who are remaining. Again, this is section 2. This is being recorded with section 2 on Monday, September 8th at approximately 2:30 now. One other thing that I brought up that I think is worth putting on the video for later review is it sort of ties into a review of the idea of forum selection clauses and that sort of thing. In a prior module, I guess it was module 1, I had discussed forum selection clauses, which are clauses in contracts that select the forum, meaning they choose where any dispute arising under the contract is going to be heard. That could be a court in a specific location, it could be arbitration in a specific location, it could be mediation, but that's a forum selection clause. And I mention that in the context of personal jurisdiction because in contracts, if both sides agree to a forum selection clause, then there's not a real issue about whether there's personal jurisdiction over the defendant because they've already consented to it. But what I wanted to talk about here is a little nuance in the Lloyd's Open form, and you'll see it in the reading. I think it's primarily in a footnote. Lloyd's Open form, being an English document, I think pretty much all versions of it have a forum selection clause that calls for arbitration in the United Kingdom. And almost universally, courts will enforce forum selection clauses in contracts. The rare exception, or one of the rare exceptions, happens to be mentioned in the electronic textbook, and that's a case in which a couple in Florida signed a Lloyd's Open Forum that had a forum selection clause calling for arbitration in the UK. They didn't want to do that. They didn't want to have to fly to the UK to resolve the dispute with the salver, and so they went to federal court, I believe, in one of the districts in Florida, and the court, rather unusual for a forum selection clause case, actually did not enforce it, and I think he or she proceeded to have the case, to order the case to be heard in an arbitration in the United States. But that's rare. But I mention it because Lloyd's Open Forum typically does include a forum selection clause, and as I understand it, not having reviewed every version, it's typically going to be arbitration in the UK. So that's just a sort of a tangential point that connects us to forum selection clauses and their use. I guess that's about it for now for this segment, and we will reconvene later.